Hello, and welcome to the lecture series for Ethics in the Legal Environment. I'm the instructor for the course, Roun McNeal, and this is the second lecture in a unit on special clients and circumstances. In the last lecture, we examined how lawyers deal with the special circumstances of corporations and organizations, as well as clients with diminished capacity. There are several other special circumstances we will cover in this lecture. This is a bit of a hodgepodge lecture, but at the end, I will review the most important points. First, I want to pay some special attention to the duties owed to prospective clients, whose cases the lawyer ends up declining. Attorneys generally do not have to accept representation of clients who, for whatever reason, may pose some difficulty for the attorney. Lawyers have discretion about which cases they want to accept. However, attorneys owe limited duties to prospective clients. A prospective client is any person who knowingly seeks the advice of an attorney relating to a legal matter. The material consideration is the state of mind of the prospective client. Does this person believe that he or she is seeking legal advice? If the answer is yes, then he or she is a prospective client. So a person on the street who walks up to a lawyer and asks about a hypothetical legal issue out of curiosity or interest may not be seeking legal advice. The attorney owes that person no special duty. But if the person on the street is asking a question and seeking advice, then that person is a potential client, and the attorney would owe them a duty. For starters, attorneys owe the duty of confidentiality to prospective clients, and that duty extends to the attorney's staff. Sometimes that duty of confidentiality arises in situations where the attorney is mandated to decline representation. When accepting a prospective client would create a conflict of interest with an existing client, for example, the attorney would be required to decline to represent the prospective client, but the attorney would also owe a duty of confidentiality to that prospective client. This means that if a prospective client's interests are materially adverse to an existing client, representation should be declined as soon as the attorney has enough information to determine that the conflict exists. There are also circumstances in which an attorney has taken on a client but must then withdraw because a conflict arises or is uncovered. This situation is called mandatory withdrawal. We will examine a few circumstances that might mandate withdrawal and cover how to ethically withdraw without unduly prejudicing the client. There are three common examples of mandatory withdrawal. The first is where the representation would result in the violation of ethical rules. Perhaps a conflict of interest arises, or the client asks the attorney to participate in unethical conduct. A second is when the attorney is materially impaired because he has become mentally or physically incapable of continuing the representation. A third is when the attorney is discharged. It seems obvious that when an attorney is fired, he is mandated to withdraw, but I mention it here because discharged lawyers will have continuing obligations to their clients. It is perhaps especially important to be vigilant about one's ongoing duties to clients who the attorney is probably angry with for discharging him. An attorney in a mandatory withdrawal scenario has no discretion about ending the representation. It must end. But it is certainly possible that the lawyer would be owed some compensation or fees for the work that she has done prior to the mandatory withdrawal. In many circumstances, a lawyer who is required to withdraw will have performed reasonable service that is of some value to the client, and she would be entitled to compensation for that service under a contract principle called quantum meruit. Quantum meruit translated into English means as much as is deserved. So where a legal services agreement or retainer agreement does not otherwise specify by contract the amount of compensation for such a lawyer, she can rely upon the principle of quantum meruit to recover some compensation. There are some caveats. First, in order to recover under quantum meruit, the withdrawal must have been mandatory. If an attorney chooses to withdraw, she may be waiving the value of the work she has done so far. The lawyer also cannot use ethical rules as a ruse to withdraw. The ethical considerations must be the primary motivation for the withdrawal. It may also be required that the client subsequently and eventually obtains recovery and wins money damages. This is especially true in contingency fee cases. Finally, the attorney must demonstrate that her work contributed to the recovery. If a lawyer works for 6 months on a medical malpractice claim before withdrawing, then her successor totally changes the theory of the case and wins without using the work product of the first attorney, then that first attorney might not be entitled to compensation in quantum merit. Let's delve a bit deeper into one of the reasons an attorney might be mandated to withdraw, being as a result of a disability or an impairment. Health issues, personal problems, even the stress of the law practice can lead to a diminished capacity to practice law. If an attorney's performance is directly compromised by some disability, he can and should withdraw. Overwork, stress, and mental or physical disability are not automatically indicators of diminished capacity. Lawyers can experience mental or physical ailments that might make practice different or more difficult, but still possible. So not all disabilities rise to the level of impacting a lawyer's fitness to practice. There is an obvious tension. How does the compromised practitioner recognize that she needs to withdraw, decline work, or seek help? There's not an easy answer, but the disability does not provide an excuse either. Lack of recognition of deficiency is not an excuse for an ethical violation, as you'll see from 2 cases I will reference in a moment. While lack of recognition of a deficiency will not excuse an ethical violation committed as a result of the lawyer's disability, the sanctions for that violation can be mitigated if the lawyer is able to show that he did not purposefully neglect his practice and duties. A lawyer can show that by presenting medical evidence of an impairment, that the impairment caused the misconduct, that the lawyer has sustained a meaningful and successful period of recovery, that the misconduct has stopped, and that a recurrence of the misconduct is unlikely. Note especially the requirement of a substantial showing of successful work toward recovery. 2 cases help to illustrate how ethical boards deal with lawyers who have become impaired or disabled. In Lawyer Disciplinary Board versus Dues, an attorney experienced a heart attack, bypass surgery, 3 hospital admissions, and prostate surgery in the span of 2 years. In another case, in Lawyer Disciplinary Board versus Blyler, the attorney's misconduct happened amid his increasing role as a caretaker for his wife, who had Alzheimer's. In each of these cases, the court recognized that the sanction against the attorneys who actually did fail in their duties of competence and diligence to their clients should be mitigated because of their own disabilities or disabilities of a loved one seem to indicate that their failures were not entirely voluntary. However, a West Virginia court case showed a lack of sympathy when dealing with a lawyer who appeared to be using his disability as an excuse. In Lawyer Disciplinary Board versus Scott, the responding lawyer was found to have falsified documents and lied to clients and judges to cover up his mistakes in his practice. He produced evidence of a diagnosis of bipolar disorder, but his treating psychiatrist testified that dishonesty is not a symptom of the disorder and could not have been the cause of his improper actions. Because the board was not satisfied that the disability caused the misconduct, the lawyer was suspended from practice for 3 years. Let's turn the page on disabilities and impairments and look at permissive withdrawals. We've covered reasons that an attorney may be required to withdraw from representation, but what about times when an attorney chooses to terminate the representation? While an attorney is not generally required to take every case that walks in the door, once he has accepted the client, the lawyer may not automatically withdraw. Certain conditions must be met for the lawyer to withdraw if he is choosing to do so and is not mandated to do so. Let's look at some of the reasons a lawyer might be motivated to withdraw. The first is similar to a mandatory withdrawal reason. If a lawyer has a reasonable belief that the client is using, will use, or has used the attorney's services to perpetuate a crime or fraud, an attorney may withdraw. Now, this is distinct from mandatory withdrawal because of the level of certainty that the lawyer has in his belief that the client is engaged in illegal conduct. A lawyer who knows that his services are being used to perpetuate a crime or fraud is mandated to withdraw. But if his belief is less certain, the rules of ethics permit withdrawal but do not mandate it. Another reason an attorney might seek to withdraw is a personal repulsion or fundamental disagreement with the client. Once again, we are presented with levels of degrees. If the fundamental disagreement will inhibit the lawyer's ability to do his job, he must withdraw. If he feels he could do the job, albeit uncomfortably, he is permitted to withdraw. Two more reasons are more practical. First, a client might be in violation of the legal services or retainer agreement, failing to fulfill his obligations under the agreement. For example, perhaps the client is not paying his bills, or not communicating with the attorney, or participating in the litigation. Violating the terms of the legal services agreement is essentially a breach of contract, and that may permit a lawyer to withdraw. Another possibly related reason might be the financial burden imposed by continuing to represent the client. Sometimes litigation is expensive and protracted. It can get too expensive and protracted for some lawyers. In this case, a lawyer might be permitted to withdraw. In all of these circumstances, a cardinal rule applies. If an attorney is seeking permissive withdrawal from a case, there must be no material adverse impact on the client's interests. Because the reasons for withdrawal must be weighed against the possibility of adverse impact on the client, generally, permissive withdrawal requires a motion and order from the court in which the litigation has been filed. The closer to trial the litigation has gotten, the more likely it is that the court will presume an adverse impact on the client. The complexity of a matter may weigh against withdrawal because the more complex the matter, the more difficult it may be to find a competent attorney to handle it. If a request to withdraw is not granted, then the attorney must see the representation through to its conclusion. So you see, while an attorney is not usually required to accept a case, once he has taken on the client, he is not automatically given the option to withdraw. No matter the reason for withdrawal, an attorney must take all steps necessary to preserve the client's rights and advise him of any issues. The attorney must facilitate transfer of clients' files, and the attorney must be mindful of deadlines, particularly statutes of limitations. A withdrawing attorney needs to take into account the specifics of the situation and be concerned with the client's interests during and after withdrawal. Let's look at two cases and two issues that flesh out permissive withdrawal. First, Elton versus Doherty. This is a Florida case in which an attorney was no longer willing to front the expenses of litigation, and the client was unwilling or unable to pay the expenses. Doherty was suing tobacco companies for injuries sustained after years of smoking. The attorney, Elton, did some investigation and deposed Doherty's pulmonologist, who testified that Doherty was predisposed to asthma and probably would have developed it whether she had smoked or not. As a result of this deposition, Elton did not believe that Doherty could win her case, and he sought to withdraw. Doherty opposed the withdrawal and sought to force Elton to see the case through. The trial court granted Elton's motion to withdraw, and the appeals court affirmed, specifically noting that Elton sought a continuance to give Doherty time to find a new lawyer, and that Elton advised the client immediately after deposing the doctor that he did not think that the case would be successful, which was his sole motivation for withdrawing. A couple of other cases support some principles about withdrawal, which have been covered in other lectures. Pritt v. Suzuki Motor Company Limited is the civil state law case involving an attorney who discovered that his client had made material misrepresentations about injuries sustained in a car accident. The attorney discovered that the material misrepresentations during the trial after Suzuki produced a hired private investigator who took videos of Pritt performing labor that was inconsistent with his alleged injuries in impeaching Mr. Pritt's testimony about those injuries. The court declared a mistrial, and Pritt's trial attorney, who had taken the case on contingency fee, was granted withdrawal and demanded fees in quantum meruit. In another case, Staples versus McKnight, this deals with an attorney, McKnight, who withdrew after her client, Staples, declared his intention to lie in a deposition. Lawyers can withdraw if their clients intend to commit perjury. In this case, McKnight sued Staples for the anticipated fee in the case, even though McKnight had withdrawn from the case. At a jury trial, the jury entered a verdict for McKnight and awarded damages, but on appeal, the Texas Court of Appeals held that Staples' statement about what he intended to testify at the deposition was not explicitly a lie. So while affirming the principle that lawyers can withdraw when they anticipate perjury from a client, the court sent the message that anticipation needs to be explicit. One case that does a good job of explaining a situation wherein the attorney might not be permitted to withdraw is Smith versus R.J. Reynolds Tobacco, another tobacco lawsuit. This case deals with the material adverse effect on the client of handing off a complex lawsuit to a new attorney close to the trial because the lawyer who took the case is losing money on it. The key distinguishing factor between the Smith case and Elton versus Doherty, cited previously, is the amount of time that the attorney in this Smith case allowed to elapse and the proximity in time to the trial before explaining to the client that the case was probably a loser. So if an attorney wants to withdraw from a case that she doesn't think she can win, she better do it as soon as possible. When it comes to permissive withdrawal, you can see that it might really be described as possible permissive withdrawal, because it is not guaranteed that an attorney may withdraw at all. Why is this? Well, because clients should not feel as if attorneys can abandon them midstream. Lawyers are expected to be sophisticated professionals who should know whether it makes sense for them to take on a case. If it stops making sense for the lawyer, the system will not permit the lawyer's convenience to prejudice the client. The burden will be placed on the lawyer. Our next unit will cover issues surrounding litigation and advocacy and a lawyer's duties to opposing counsel, the courts, and the public. Until then.